Detection of crime. While we do know that crime is down, crime rates are down, there's still an issue that many crimes go unreported. And there's three basic reasons for this. The first reason is that individuals believe the police won't assist when a crime is reported. A couple of reasons for this. One might simply be they know the police cannot do anything to help. I will give you an example. I was a victim of a crime a few years ago. Somebody broke into my vehicle. They broke my car window. They got in and they took all the change out of my center console. Why am I going to call the police? I know they can't do anything about this. They can't trace the change. It's going to be low priority. They're not going to send anybody out to try and fingerprint the car or anything like that. So we believe that the police won't assist, or they can assist when a crime is reported. The second reason is there's a mistrust of authorities. We see this especially in the immigrant population where they are fleeing government abuse and abuse of powers. So we think that, they think that what occurred in their home country is going to occur here. And it's not necessarily an immigrant issue. We do have people here that will occasionally abuse their power, and it causes the community as a whole to mistrust authorities. So we may not want to deal with authorities. We may not feel that they will look out for us. We may become the criminal. The last reason is simple. There's an unwillingness to report a friend or relative. I mean, can you imagine that you know your best friend's son robbed your home, or that your niece stole something from your house? How are you going to confront them? Or if you call the police and you're responsible for them going to jail or them going to prison? Especially in the family. What is this going to do to the family dynamic? What is this going to do to the family relation? But we have a crime, we have a criminal, we have a victim. The victim says, okay, yes, the police can help me. They call the police. So the police will go about gathering evidence. A couple of things we need to know. The U.S. Constitution prohibits something called unreasonable searches. This is the Fourth Amendment. It says that the police must have a reason to search you. Usually police must get, and usually they must have a warrant. However, warrants are not always required. A search warrant is not always required. So if the police thinks it was a reasonable search, if they had a reason to search you, you might have been destroying evidence. A crime was getting ready to be committed. They had a reason to stop you. They had a reason to search you. They do not require a warrant. Well, who determines the reasonableness of a search? Who determines if you had probable cause to do a search? Well, that's simple. The courts. The courts will determine during the trial session if the search was reasonable. This determination on probable cause is usually made by a magistrate. If they say the search was reasonable, you acted constitutionally as a peace officer, that's fine. Your issue is if the court decides that your search was not reasonable, that it was unreasonable. If the search is unreasonable, any illegally obtained evidence is not going to be allowed in court. So if you obtained something illegally, you should have waited and got a warrant and you didn't, you found drugs, those drugs are not going to be allowed in court as evidence. Confessions as part as evidence. Much like searches, illegally obtained confessions are unconstitutional. This came from Miranda versus Arizona, a case the Supreme Court decided back in the 1960s. I've included a link to the case brief describing the court. And all of us, well, pretty much all of us, the majority of us know what our Miranda rights are, even if we have never been involved in law enforcement. You watch TV, you have seen these. What are your Miranda rights? You have the right to remain silent. Any statement you make may be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be appointed for you. These are your Miranda rights. These are your confessions. Before a confession is considered legal, they have to tell you what your Miranda rights are. And anything they do, if you request an attorney or if you state, I am asserting my Fifth Amendment right to remain silent, I want my attorney, they cannot ask you questions. They have to leave you alone until your attorney's present. Once again, any violation of these constitutionally protected procedures means any evidence obtained is not legal. Formal charges. They've gathered evidence, they've figured out who committed the crime. If we're talking about a felony, the case is bound over for a grand jury. The grand jury is the one that decides, yes, there's enough evidence here to think a crime was committed and further investigation must happen. Further investigation needs to happen. This means that the grand jury will issue what's called an indictment. This is the start of the trial. So if the grand jury indicts you, you will have an arrest warrant issued. The odd thing is arrest in itself is a form of punishment. And I say this because remember in our city that, or excuse me, not in our city, in our Constitution, we are assumed innocent until proven guilty. But I've included this copy of a news story, I'm assuming it's still there, on this prostitution arrest. Is it going to bring it up for me? Look, see, 24 among, or pastor among 24 arrested in prostitution sting. If we are considered innocent, how is an arrest a form of punishment? Well, this is simply because your face is plastered on TV.
Your businesses and a school. There's an unwelcome sight. And it's no secret. Prostitution is rampant.
All hours of the day, all hours of the night. It's just something that you see.
So did the Sacramento Sheriff's Department. They launched an operation to send a message, and many ended up in handcuffs. Arrested 8 women for prostitution and 16 men for soliciting prostitution. One of the suspects includes 50-year-old John Oselski from the Grace Family Church in Carmichael. Police arrested him on Myrtle Way and Watt Avenue, just a block from Oakdale Elementary School. That's where Mary Gower's daughter goes to school.
We were walking yesterday morning. My daughter did say, that girl looks a little too fancy, wonder where she's going. And I'm like, I don't know, honey, maybe to work. And then we just kept walking. Like, I don't know what to say to my kids. And it's really sad that I'm a mother in this position with a 7-year-old, a 5-year-old, and a 3-year-old. How do you explain this to these kids?
And police say a teen was also arrested. A 16-year-old girl now facing prostitution charges.
She will likely be either picked up by her family or placed into the juvenile hall center or something until we can rightly find out where she belongs.
Gower is relieved with arrests, but she hopes investigators don't stop there.
There's so much more out there. There is just so much more out there.
Why do I say that arrest in itself is a form of punishment? You've been arrested, you've been charged. But have you been found guilty? No. Yet these people, the 8 women, 16 men, their picture was plastered on the TV. in front of everybody to see, saying, they've been charged with this crime. Well, yeah, they've been charged, but that doesn't mean they're a criminal. Just because you're charged does not mean you're guilty. So yes, arrest in itself is a form of punishment. Arrest is telling the community, we think you committed a crime. We see magistrates, we see judges, and this is if you're not in custody, if the grand jury issues the indictments, the magistrate will issue an arrest warrant. That's telling the police, yes, you have reason to go arrest them. This is legal. However, police may arrest without a warrant if there is probable cause or circumstances do not permit their obtaining one. An example, a police officer observes you. It's late at night, you fail to maintain a single lane, you almost hit the barrier, whatever. They pull you over, they get out of their car, they come to talk to you. As they're talking to you, they observe you that you have bloodshot eyes, your speech is slurry. What am I saying? You're probably intoxicated. There is probable cause. Police have reason to believe that you have broken the law. They do not need a warrant to arrest you because they do have probable cause. So a warrant, whether it's a search warrant or an arrest warrant, is not always needed, but it helps to have one. It helps just to cover yourself legally. The accused has been arrested. So what happens to him next? The accused is presented before a magistrate or a judge. Same thing. The term is interchangeable. The charges against the accused and his basic rights, his or her basic rights, are explained. You're reminded of your rights, your constitutional rights. You're told that you have the right to an examining trial. You have the right to a trial by jury. The government, remember the government's always going to be the prosecution in a criminal case at the trial level. The government has to prove that you are guilty to a jury. Bail may or may not be set. Bail allows you to leave jail, go home to your normal life, to your work, while you're waiting to resolve your legal issues. Pretrial hearings. At a pretrial hearing, a defendant can enter a plea. The plea is going to be either guilty or not guilty. If the plea is guilty, a hearing is scheduled at a later date to set punishment, to decide, length of time, where is it going to be, the amount of the fine. Or, if you plead not guilty, the case is placed on the docket for trial. The docket is the court calendar. That's all the docket is. Pretrial hearings may be used for other things. We see motions presented in pretrial hearings, and there's 4 types of motions I want to discuss. The first is a motion for a continuance. All of this means is that you go into court and you say, Your Honor, I'd like to file a motion of continuance. I am not ready today. I am not set to go. Can we postpone this court date? This can be filed by either the plaintiff or the defense. The second motion is the motion to suppress. This is going to be the motion to suppress certain evidence. Your Honor, I would like to file a motion. The drugs obtained were obtained illegally. They were obtained under an illegal search. Which side is going to file a motion for suppress? Is it going to be the plaintiff? Is it going to be the state? Or is it going to be the defendant? It's going to be the defendant. The state wants every piece of evidence in there they can get to help prove guilt. So the defendant is the one that files a motion to suppress. Motion for insanity. Say, my client is not mentally stable. He is not mentally right. He did not know right from wrong. We need to get his sanity tested. Is he insane? That's another motion. The last motion I want to mention is a motion for a change of venue. Venue is the geographical location that the trial is going to be held in. We want to change it. How can we want to change it? Remember these procedures that we are trying to protect. The defendant has certain legal protections. We want to make sure the defendant receives all his legal protections because we are talking about fining him. We are talking about incarcerating him, taking away his freedom. Why would we want to change venue? Imagine that somebody is accused of sexually assaulting a child in a small town. Everybody knows everybody, or almost everybody is related to the victim. Whether this person did it or not, just because this person is accused, do you think they will get a fair trial? Or is the jury pool going to be predisposed to be guilty? This might be a reason for a change of venue. We want to change it to a location where the person's going to get a fair trial. In all reality, we don't go through trial. We have something called plea bargaining. And most cases end in a plea bargain. This is a secret bargaining session with the prosecutor. It may be that the defense attorney will go up and say, my client will plead guilty if you lower the charge, if you reduce the charge from driving under the influence to reckless driving. Or my client will plead guilty for the driving under the influence if you offer him 10 days in jail, if he doesn't have to do more than 10 days, if he doesn't do the 180 days. Plea bargaining, it's acceptable because it saves tax money and court time. We are not having to spend money on simple cases that shouldn't be tried, taxpayers' money. We're not having to hire witnesses. We're not having to pay the jury. We are able to use the court resources for more important. That would be a pro. However, there are also cons. The major con to a plea bargain is we see people that are pleading guilty to crimes they didn't commit simply so they can get out of jail, they can return to work, they can support their family. It ends up being a lot cheaper than actually going to trial. You know, these days, if you're accused of DUI, a DUI defense is going to cost you about $20,000. If you have an option of paying $20,000 or doing 10 days in jail, 5 days in jail, what are you going to do? Most people don't have $20,000 to spend, so they'll say, give me the jail time, let me get this portion of my life over with so I can return to work. I can move on. However, if you didn't reach a plea bargain, you pled not guilty, and you go to the trial. In a trial, either the judge or jury determines the verdict. The choice is the defendant's. They get to choose whether they want a trial by judge or a trial by jury. The judge will determine the verdict, the guilty, if the trial by jury is waived. Texas law requires that all jurors on a criminal case, they must agree on the verdict. So this means that a criminal verdict or a guilty verdict in a criminal case must be unanimous. All the people on this jury must agree. What's the advantage of a trial by judge versus a trial by jury? Well, the advantage of that trial by jury is, remember, they have to find you guilty beyond a reasonable doubt. If you can convince one person that you might not have done it, they can't find you guilty. How come you might want a judge to find you guilty? A judge, not to find you guilty, excuse me. A judge to hear your trial, to decide. What if it's very technical? Do we want somebody off the street that may have no experience in this area judging you based on this? What if you're basing a lot of it on forensic evidence? Forensic evidence. I don't know what I was thinking. Forensic evidence that the judge deals with on a daily basis, but the common everyday person wouldn't understand. In that case, you may want the judge to decide your case. Remember, I said the prosecutors must prove guilt beyond a reasonable doubt. If they don't, if one person says, no, I don't believe he did this, this creates what's called a hung jury. And a hung jury is simply when jurors cannot agree. If there's a hung jury, the prosecutor has the option of retrying your case. If there's not a hung jury, if we get a guilty sentence, the judge or the jury can decide your punishment. Post-trial proceedings. A person who has been acquitted, who has been found to be not guilty of the charges, cannot be tried again for the same offense. This is called double jeopardy. What this means is that if the state loses, they cannot appeal a not guilty verdict. If the jury or the judge says, state, you did not appeal your case, that's it. They don't get a second shot. They cannot appeal to the Court of Appeals and say, give us another shot. This is what they did wrong. Or they cannot say, well, we're going to try you again at the trial level. Excuse me. They cannot try you again at the trial level. That would be a violation of double jeopardy. Juvenile courts in Texas are special. Even though they break the law, they are criminals. Texas, when it comes to juveniles, we are more about rehabilitation than punishment. With this in mind, juvenile proceedings are civil. So there's not going to be any incarceration as a punishment. The records from a civil court, from a juvenile case, may be sealed from the public with the approval of the juvenile judge. This means we may never know the facts of the case, what they were accused of doing, the turnout, what the holding or what happened with the case. In Texas, children as young as 14 may be certified to stand trial as an adult. However, the usual age, or the age of adulthood in Texas, is 17. So once you hit 17, you will be tried as an adult. However, depending on your crime, if you're as young as 14, you still may be certified to stand trial as an adult. I've included an op-ed that was written. It's an opinion about changing the age of juvenile courts, changing the age of adulthood in Texas from 17 to 18. It lists their reasons why they think we should do it. You've gone through your trial, you've been found guilty, you have been incarcerated, you've been given a sentence that includes incarceration. You now become a member, or you fall under the authorization, the authority of the Texas Department of Criminal Justice. TDCJ, it used to be Texas Department of Corrections. TDCJ supervises the state's adult correctional functions. The first one they supervise is what is commonly called probation. The correct term is community supervision. You're found guilty of a crime. Instead of being incarcerated, you're being placed on community supervision. There are certain conditions that must be met. It keeps you out of jail. It keeps you out of prison, the state penitentiary. But there's things. You must check in with your probation officer every month. You must pay fees. You must pay fines. You're subject to drug testing. You must work. There are certain conditions for the different crimes that we have. Another option is prison, is incarceration. You can go to prison, you can go to jail. You're going to lockup. Texas Department of Criminal Justice oversees this area also. The final area is parole. You're locked up, you have not finished your sentence, but they say, the Board of Pardons and Parole says, you've been a good citizen or you've been a good prisoner, we're going to let you out early on parole. You are still under the authority of the Texas Department of Criminal Justice. You still have to do what they say. However, we are letting you out of lockup. You can go continue your life on the outside. Clemency. This should be a recap. We talked about clemency when we talked about the governor. The Board of Pardons and Paroles make recommendations to the governors. This can be pardon you of your crime, commutation, or a reprieve. We've gone over all of these. The last thing I want to discuss is the use of jails or prisons. I need to fix that. That's a picture of Alcatraz. Jails or prisons can be used for one of four reasons. First, it's punishment. You committed a crime, we are going to lock you up. We are going to incarcerate you as punishment. That's one possible use for a jail or a prison. The second use is deterrent. If you understand that you may lose your freedom, that you may be incarcerated, this will cause you to not act on your criminal tendency, to act on your criminal wants. The third reason we have jails or prisons is isolation of criminal elements. We're going to keep you away from the law-abiding members of society. And the final reason is rehabilitation. We lock up people because they don't have any other skills. All they know is the criminal life. We're going to rehabilitate them. We're going to give them life skills, job skills, so that they can make it in the outside world. They can become law-abiding citizens. They can support themselves. Now, the question posed is, out of these four, what is the proper use for a jail or a prison? If I ask you individually, what are your answers going to be? Some of you are going to say punishment. Some of you are going to say rehabilitation. Some of you are going to say deterrence. The answer to my question is, there is no right answer. The proper use for a jail or prison, one of these four items, is going to be an individual feeling. It's going to be an individual opinion. Not everybody is going to agree on the proper uses of jails or prisons.